at trial non-standard catering option riders pursuant to the order issued in docket number 11-10007. This matter has been designated by the Commission as docket number 12-05003. Appearing for the Commission today are myself, Elena Burtenshaw, Chairman and Presiding Officer, Policy Advisors Craig McDonald and Al Anderson, and Administrative Attorney Shelley Cassidy. Appearing for Nevada Energy.
Good morning, Chairman Burtenshaw, Sean Olsegi, and with me is Mike Milano and Gary Smith.
Appearing for the Bureau of Consumer Protection.
David Norris, and with me is Dan Jacobson.
Appearing for the Commission's Regulatory Operations staff.
Good morning, Chairman Jermaine Grubbs.
Are there any other persons who would like to make their presence known to the Commission for the purpose of this hearing?
Can you speak louder?
Are there any other persons who would like to make their presence known to the Commission for the purpose of this hearing? Let the record reflect that no other persons have come forward. The record should also reflect that the notice of hearing was made on July 2nd, 2012. The Commission has in its files affidavits of publication regarding the notice of hearing. Are there any persons present that wish to examine those affidavits or have any concerns related to the notice of this hearing? Let the record reflect that no one has come forward. The Commission deems this matter to be duly properly noticed for hearing at this time. Do we have any further issues? Ms. Grubbs, Mr. Elsie, and Mr. Norris?
None from us, Commissioner.
None from the company, Chairman.
None from staff.
Okay. All right, so do we want to start marking the exhibits?
Yes, please. We'll start with the application. I have that marked next in order.
The joint application of Nevada Power Company and Sierra Pacific Power Company will be marked as Exhibit 1.
For the sake of clarity, there were two exhibits to the application. For those marked as part of Exhibit 1, or should I mark those separately, Chair?
Let's go ahead and mark this exhibit.
Okay. May I have Exhibit 1 to the application marked next in order?
Exhibit 1 to the joint application of MU Energy will be marked as Exhibit 2.
And may I have Exhibit 2 to the application marked next in order?
Exhibit 2 to the joint application of MU Energy will be marked as Exhibit 3.
May I have the prepared direct testimony of Gary Smith marked next in order?
The prepared direct testimony of Gary Smith will be marked as Exhibit 4.
And MB Energy's first witness is Gary Smith.
Do you solemnly swear the testimony you're about to give before the commission shall be the truth, the whole truth, and nothing but the truth?
Yes.
Oh, this should be good. Mr. Wilson?
Mr. Smith, would you please state your name and spell your last name for the record?
Gary Smith, S-M-I-T-H,
By whom are you employed,
MD Energy,
and in what capacity are you employed, sir?
the Director of Customer Energy Solutions.
Do you have a copy of Exhibit 4 with you?
Yes, I do, sir.
What is Exhibit 4?
My direct testimony?
And was Exhibit 4 prepared by you or after correction?
Yes, it was.
Do you have any corrections to Exhibit 4?
I do not.
If I were to ask you the questions set forth in Exhibit 4, would your answers be the same?
Yes, I will.
Do you adopt Exhibit 4 as your testimony given today?
Yes.
Mr. Smith is available for cross-examination.
Mr. Norris?
Thank you, Chairman. Mr. Smith, directing your attention to page 5 of what's been marked for identification as Exhibit 4. It begins with line 4, and there you make this statement. First, an opt-out tariff could result in a situation where the companies fail to satisfy a material obligation under the Department of Energy funding agreement. You see that there?
Yes, I do.
Could you describe some of these obligations that could be affected by an opt-out tariff?
There's two concerns with an opt-out tariff regarding the funding with the Department of Energy. The first is we made application with the Department of Energy for the smart grid investment grants. And part of that application was smart meters themselves. And we committed to the Department of Energy that we would be doing a full statewide deployment of smart meters. And with an opt-out tariff, obviously, it was reducing the quantity of meters that have been deployed. The second part of that has to do with the funding obligation we have with the Department of Energy. And that funding obligation has a specific plan by which they're being reimbursed for the associated costs with the install of the smart meters. We may not equal the total funding obligation of the grants if we were to reduce the quantity of meters that we would be deploying within the service territory.
So I guess that you have two concerns. One, I presume, is that the something in the opt-out tariff could jeopardize the funding altogether, and the other is whether you would collect all of it or not. Is that correct?
That's correct, sir.
And just, what happens if the funding is jeopardized as you put it? I mean, what exactly does DOE do?
Well, in the orders that we received from the Commission, we were directed to go back to the Department of Energy and ask the Department of Energy what impacts an opt-out provisions would have on the funding of these two items. Working with our project technical officer, we worked out a method by which if the quantity of opt-out customers was what we have estimated to be, that there was a way to work through that.
Now, first of all, you testified in docket number 10-02009, did you not?
You have to refer to what that document is.
That was the first resource plan in which the smart meters were considered the ASD project.
That is correct, sir.
And I don't recall who exactly said this, but I believe it was represented by someone at the company that DOE originally wanted these smart meters to be mandatory to cover all customers for NDE.
You have to define the word mandatory.
Well, in other words, everybody was going to get a smart meter, whether they wanted one or not. There weren't going to be any opt-out tariffs.
Mr. Smith, before you respond, can you try to get closer to the mic and talk louder? Folks can't hear you.
Sure, Chairman. So.
And also, if Mr. Norris has a specific representation by the company as opposed to his memory, it might be helpful to refresh Mr. Smith's recollection of his testimony or the company's testimony.
You know, I don't recall other than it was either Mr. Smith or it might have been Ms. Walsh who made that representation in the 2010 case. I don't have a reference. I'm asking him if he remembers it.
I would have to see that documentation.
Did the company at any time with DOE discuss the possibility of an opt-in tariff? In other words, customers wouldn't get the smart meters unless they wanted them.
Not to my recollection, no.
On your, well, first of all, at the bottom of page 5 of your testimony, and actually, I would say, no, this is really Q&A 12. It begins at line 11. You approached the DOE to see if there were any specific enrollment caps for the opt-out tariff. Is that correct?
Per the Commission's order, we were asked to go back to the DOE to see if there was impacts regarding a cap that would impact the funding itself.
And you indicated the DOE could not provide a definitive subscription cap. Is that correct?
I received through verbal discussions over the phone and then a follow-up email confirming this. That is correct. They looked at the quantity of the postponement list that we had at the time. They didn't see the quantity as being a material impact at the time of that discussion. We talked through a method by which we could establish a cap, and it had to do with two items. The first was an anticipated meter failure rate of our the smart meter of 0.05% and about a 1% growth rate that we would have within our inventory. And we use those as the basis for establishing a cap, being that we will still go out and purchase about 800,000 residential meters for the Southern Nevada Territory and 300,000 residential meters for the Northern Territory. The subscription cap itself, the number of opt-out customers was capped for each individual territory based on knowing that we would have the inventory and the failure rate estimations to be able to still receive the full allocation of the funding at the end of the project.
Well, let me make sure I understand what the company's position here. Based on the application that was filed, in essence, the company estimated subscription caps. Is that fair to say?
We did the estimate based on working with the Department of Energy of what would be acceptable. They did put a caveat, however, if this number was to increase, and they didn't give a range of what that increase would be, that they would revisit the issue.
So as we sit here today, the company has no idea what actually is the threshold that has to be reached in terms of opt-out customers before DOE funding is actually jeopardized.
That comes in two parts. One is that the meters I mentioned, the 800,000 in the south and the 300,000 in the north, fulfills our obligations under the grants. So we would get full reimbursement under the grants by actually receiving those meters.
Let me ask this question. How much reimbursement have you received so far for the cost of the meters, the smart meters?
I don't have the specific breakdown for smart meters themselves, but I know that through August we've received about 121 million of the 139 million of the grant obligation back from the DOE.
So you received roughly in excess of 80% then of the total commitment of DOE?
Roughly in that range, yeah. We're about 89% complete in the overall project.
I understand that, correct me if I'm wrong, but when the meters are received in inventory is when they're eligible for reimbursement, not when they're installed. Is that correct?
It's actually when the invoice is paid to the meter manufacturer.
So, and that's before you even receive them?
No, that's about 30 days after we receive them, around in that 30.
And are any of the meters installed before you receive the invoice?
No. They have to be accepted into inventory before they take place.
So the accepted number in terms of your caps here could be higher than 12,000, couldn't it?
I don't understand your question.
Well, in other words, at the bottom of page 5, the enrollment caps are 12,000 for Nevada Power, 4,500 for Sierra. It's possible, is it not, that you could actually, or the enrollment cap could be increased over 12,000, not necessarily jeopardize DOE funding?
If the number of opt-out customers were to drive that, that could be an impact on funding.
Did DOE give any reason why it won't advise the company what the actual number is?
No, in the industry, believe it or not, even for DOE, this is a new topic. And, we're all trying to work through providing customer choice while working through the original plans. So this is something that's is new to them and it's new to the industry.
things that you indicate in your testimony is that there's a special condition. This is on page 7, Q&A 15. There's a special condition number 2, which prevents customers who receive service under the trial SMNO tariff from requesting service under the optional time of use schedules. See that there?
That is correct, yes.
Now, the company has had optional time of use rates for quite some time, has it not?
That is correct, sir, yes.
And in fact, you had those rates when everyone was on an analog meter, didn't you?
Yes, we did.
And you indicate the reason that the customer would not be eligible for that optional service is because the meter that will be used, the non-standard meter, will not record interval information. Is that correct?
That is correct.
Okay, explain to me why it is that you could allow or provide this service with analog meters, but you can't do it for these same customers if they're on the NSMO rider.
At this current time, we've only got one non-standard meter that is qualified or presented under this document.
Well, I'm trying to understand, how do the reporting on intervals affect the optional time of use rate?
The metering itself, when a customer signs up for time of use today, we go out and exchange their analog meter, which just collects standard usage information with an interval meter.
Is that the same meter that is now designated as a smart meter, or is this something you had before?
The new smart meter does the same thing. It collects interval data.
Okay, and has this been a condition of that particular tariff from its outset? You've been using interval data like that?
We have been manually collecting interval data. That's correct.
On page 9 of your testimony, this would begin on line 2. You indicate any customer who feels that the companies have unreasonably refused to deny a non-standard meter can seek redress from the commission. What does that entail?
Can you put that in the context? What page you on again?
I'm on page 9, and this would be your Q&A 17, and it would begin on line 2. It says any customer who feels that the companies have unreasonably refused to deny a non-standard meter can seek redress from the commission.
Well, that has to do with condition 4 of the tariff, where we have multiple service on an existing premise. And the context around that is, particularly in northern Nevada, you may have a water heater program where there's multiple services. One may be a domestic service, one may be considered a commercial service. And what this provision does is it's allowing us to, if a customer wants to opt out of the domestic service, it's providing a provision so that they can opt out of the other type of service as well. You have garages is another example. You may have on the same premise, you may have a residential service and a garage with a service, and that's what that is about.
And I guess what I'm getting at here is two things. One, what sort of redress do customers seek, and does the company advise them of what their options are?
Obviously, the reason this was put in there is there will be some judgment. The provision was put in here to help customers that want to have an opt-out provision to work through that. If they had a well that's, on a 4-acre parcel that's away from the service itself, things of that sort. If there was a reason why we couldn't not do that, then this was put in there to allow customers to have a way to resolve that.
Well, I guess what I'm trying to get at here is there any redress that the customer has beyond contacting the Commission's Consumer Affairs representative?
They would work with our company to try to resolve a solution for
pages 12 and 13 of your testimony, this would be your last question and answer. You've indicated there that you've made, or you eliminated certain provisions of Rule 16 that are no longer necessary, and one of those is the remote metering charge for those customers who have meters that can be read remotely in presumably rural areas that are inaccessible or difficult to get to.
And this was miscellaneous cleanup of the existing rules for the new rules that are coming in.
Well, does the company save any money by virtue of the elimination of that particular provision of Rule 16?
You'd have to ask Mrs. Walsh that question.
Okay, and since she is a direct witness, you can defer any questions you like to her if you feel uncomfortable answering them. But has the company used the C1SR meter to serve remote customers in the past?
Yes, we have.
And that, in fact, is the meter that will be the opt-out meter, if you want to call it that, if the commission approves this tariff.
That is correct, sir.
And how many of these do you have in inventory?
In Mr. Christensen's testimony, he has that count for you.
And if any of these meters were not used to serve opt-out customers, if this tariff is approved, does the company have any other use for them?
We do not know.
Thank you, Mr. Smith. Those are all the questions I have.
Thank you.
Ms. Gross?
No questions, thank you.
Mr. Fonseca?
I have no redirect questions.
Mr. McDonald?
Smith, are you sponsoring testimony as to the duration of the trial in question in this case?
The trial, which
The smart meter.
that is correct, yes.
As proposed by the company, what would be the minimum duration of this program for Nevada Power customers in the South?
As far as for deployment,
Yes.
it runs from March of 2010 through March of 2013 is our obligation under the DOE grant itself.
For the opt-out?
For the program
Okay.
itself.
All right, let me back up. I'm not probably as clear as I need to be this morning. For the tariff in front of us, for Nevada Power customers, when would the program begin for opt-out and when would it end?
As soon as we would receive an order, we'd have a process and we'd start the program. But it's a tariff that's in place until such time, being that it's a trial tariff, it'd be evaluated, I believe, in the order after 12 months, but then it could be a long-term ongoing tariff if there was enough customers to support that tariff.
For Sierra Pacific Power Company customers, what would be the minimum term of this program?
We have them set up the same.
Under the proposal, though, is it the company's intention to seek either a decision on continuing or stopping the program in a general rate case?
I believe the order said it would be approximately 12 months after implementation of the program it would be reviewed, but I do believe it would be a general rate case.
Okay.
Possibly.
And does Sierra Pacific and Nevada Power have the same timing for rate cases?
No, they do not.
Is it possible, under the terms that were proposed here, that a customer in the north could be a participant in the opt-out trial for a different duration of time than a customer in the south?
With the rate case schedules, that could be correct.
And the reason why the company chose the rates to do this in the general rate case, was that in the commission's order in the investigation?
What that said is we establish tariffs, and I believe we can go back to that order and take a look, but I think it said there was a time duration of review, and I think it was 12 months after the program was established.
Mr. McDonald, if I may, I apologize, sir, but
Sure.
some of these questions may be better directed to Ms. Walsh
Okay.
specifically, but I can explain and represent on behalf of the company, reading the order specifically says that in the first general rate case, following 12 months of experience, the company will evaluate whether it should discontinue the tariff or make the trial tariff a permanent tariff. And we intend to do that based upon the draft, based upon the final report and order.
Okay. Mr. Elsegi, based on that representation you just made then, is it your opinion then that a customer in the north could be a participant in this program for a different time duration than a person in the south?
Yes, sir.
Okay, thank you. Those are all my questions.
Mr. Anderson?
Thank you, Chairman. Mr. Smith,
Yes, sir.
other than operational savings, what other benefits with the smart meter program?
Mr. Anderson, you need to speak up. The folks probably
Sorry.
won't hear it down here.
What type of benefits other than operating cost savings are there associated with the smart meter program?
Well, there's customer benefits into the program as well. And we have over 1 million customers now with smart meters, and customers are able to look at their energy usage on a daily basis. They're able to see how they're using their energy. They're able to see their bill now. They're now able to receive alerts, threshold alerts, when their bill exceeds their thresholds. There's far-reaching customer benefits around outage management, new programs. For instance, under this program is a dynamic pricing trial, which will be able to test rate options for our customers. There's distribution automation benefits that will come as a second tier level under the program. So it's pretty far-reaching when you start to look at the information that can be used to better manage the business and help customers manage their energy use.
Do all customers benefit, would all the customers benefit, you, the opt-out customers, from system and reliability enhancements from the program?
Yes, they would, sir.
Thank you. Thank you, Chairman. That's all the questions I have.
Mr. Smith, Mr. Norris asked you questions with regard to the time of use rates. And you had mentioned that you guys manually collect integral data. How do you do that?
It's actually, the meter itself has a probe, and they actually probe the meter to collect that information.
You were also asked by Mr. Norris with regard to the Rule 16 remote metering charge. Mr. Norris, you framed his question in terms of, we know we're going to be using the C1 SR meter, and you're responsible based on that question. But have you had a chance to read staff's testimony, to read Mr. Lupan's testimony?
Yes, we have.
And what is the metering option that staff is proposing is different than the C1 SR meter?
There is a difference in the meter that we were required to propose under the order. That's a drive-by solution that's remotely read by a vehicle basically driving down the street that collects the read. The testimony that we received from Mr. Lipman is a digital meter, a non-communicating digital meter, that would require a manual reading. The data that's retrieved from each of those meters is the same. It's the method by which we collect it. One is remote, and one is stagnant, if you will. You have to go out and physically read the meter.
If the commission were to accept staff's recommendation for this non-communicating digital meter, how would it affect your recommendation with regard to Rule 16?
We fully support and are willing to go forward now with that recommendation of the digital meter.
The one that Mr. Lookman's.
That's correct.
Would it affect your recommendation to change or do this cleanup in Rule 16?
I think you'd still have cleanup. I don't believe that you would have that remote requirement any longer of the existing hard to reach or hard to access situation. We would take a look at that. However, if for whatever reason you had a bad dog on an opt-out customer and you couldn't get to it, that could be another alternative to still get to the meter. But at that point, I would recommend a smart meter. They're virtually doing the same thing if you want to collect.
All right, that's all I have. Thank you, Mr. Smith.
Thank you.
Mr. Wilson?
May I be prepared, direct testimony of James Christian